Okay, this is your preliminary hearing, Mr. Perkins. I just want to caution you that anything you say here is not privileged or private. Don't say anything that you would not want the whole world to hear. For the record, this is position 29, State of Georgia versus Temujin, T-M-U-J-I-N, Perkins. Ms. Perkins is charged in warrant number 2022 WA08236 with committing the offense of theft by shoplifting. Ms. Perkins is also charged in warrant number 2022 WA08237 with committing the offense of obstructing of an officer. Mr. Perkins is present here today. He's represented by Mr. Little. The state is represented by Ms. Jefferson. Ms. Jefferson, would you swear in your witness and present your case?
Officer, would you raise your right hand, please? Do you swear or affirm the testimony that you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And you can lower your hand. And if you could state your name and where you're employed.
Yes, ma'am. My name is Kate Lam. I'm employed with the City of Marlboro Police Department since 2020.
And were you so employed on May 17th, 2022?
Yes, ma'am. I'm still employed with the City of Marlboro PD.
Okay. And on that day, May 17th, 2022, were you dispatched to the South Lake Mall, I guess an apparel store on South Lake Circle in Clayton County, Georgia?
Yes, ma'am, that's correct. That's in the South Lake Mall, Clayton County.
Okay. Was this in reference to a shoplifting?
Yes, ma'am.
And can you tell us the basis or the facts to support the charges of theft by shoplifting and obstruction that were taken against Mr. Perkins?
Yes, ma'am. When I received the dispatch call and I was received another information that the suspect was fled from the mall security heading to the Olive Garden restaurant, where I met with the mall security that advised me Mr. Perkins was inside the restaurant. So I get in the restaurant and located him. He was sitting on the table, and I was with the mall security that was him. At that time, I taking him into the custody for shoplifting. While I handcuffed him, he say he wanted to go to the prison, and after he get out, he will steal it again. And then I asked for his name. He say find out. He told me to find out, which I did. So I find out that his name is Mr. Jamarin.
You said Jamar?
Saying Jamarin Perkins.
Oh, yes.
Yeah.
Just one moment. I'm getting a Zoom invite to join somebody in courtroom 3 or room 3. I'm not sure if that's for me, which I kind of think not, but I'm going to say not now.
Yeah, Your Honor, we got the same thing for.
I clicked on the button to open all rooms because I'm still trying to find Mr. Lane, but I'm listening. He's off in digital world, but that was me. I did that.
Okay, so we're declining.
Okay. Go ahead, Ms. Jefferson.
Officer, can you tell us more about the warrant for the shoplifting? Did you observe the shoplifting? Did you observe the video surveillance noting the shoplifting, or did you get information from mall security or from the store security about the shoplifting?
Oh, yes, ma'am. So I was advised by the mall security and the store employee that Mr. Perkins went into the dressing room. He selected the outfit and then he put the new outfit in his person and left it out and left and then he left the he leave the his clothing inside the dressing room. And at that time, the store employee recognized the clothes that he wearing, and then she contacted the mall security, follow him. At that time, he fled the Salt Lake Mall.
And so he fled the South Lake Mall. The security guard told you wearing the clothing he had selected that he had not purchased.
I'm
Yes,
still listening. I'm still listening, Ms. Jefferson.
Okay.
Yes,
Okay.
ma'am. So after he put in a new outfit, so he left the store, passing all the passing the I'm sorry. So he passing all the point of sale without attempting to pay for the outfit. And at that time, the mall security approached him, and then he fled the store.
And when he fled the store, you said he went to the Olive Garden restaurant.
Yes, ma'am.
And when you encountered him, what happened? And sorry if I'm asking you the same question over and over again. I got a little discombobulated. What happened to support the facts for the obstruction charge?
So I asked him for his name numerous times. Would he say go find out it? And he refused to give me his name. So I have to use the fingerprint scanner to find out who he is.
And did you determine who he was?
Yes, ma'am.
So your obstruction warrant was based on him not giving you his name?
Yes, ma'am.
Okay. I have nothing further.
Mr. Little.
Thank you, Your Honor. Officer Lamb, you said your basis for the shoplifting warrant is based on information you got from mall security?
Yes, mall security and the store employee.
Okay, so you did speak directly to the store employee?
I did, yes.
Okay. The employee said that they were able to witness this themselves, or is this from like surveillance camera or something?
They witnessed by herself.
Okay. Were you involved in the pursuit of Mr. Perkins from the mall to the Olive Garden?
No, sir.
You talking-
The mall security did.
Okay, so by the time you made contact with him, he was already at the Olive Garden.
Yes, sir.
Okay. The clothing that he was wearing, did it have any tags or security items on the clothing?
It still have the tag.
Okay. Were the clothing taken for evidence?
After I take him go to the Clayton County jail, so we able to remove his clothing, and I return that item to the owner.
Okay. Were like any photographs taken of the clothing or anything?
No, sir. It's gonna be on my body cam.
Okay, but you were in a body cam, I guess.
Yes, sir.
Now you say when you made contact with Mr. Perkins, he made statements to you?
Yeah. Yes, sir. While I handcuffed him, so he say he wants me to send him to the prison. After he get out of prison, he will steal it again.
Did he tell you that he had any sort of mental health diagnoses?
No, sir.
It didn't come up in the conversation?
Nothing that I know of.
Okay. Those are the questions I have at this time.
Okay. Any follow-up, Ms. Jefferson?
No, Your Honor, the state will rest.
Okay, I have one question. Is it my understanding that the obstruction charge is because he did not offer his name, Mr. Perkins?
What'd you say?
Ms.
No,
Perkins, that's not a question for you.
No, yes, no, Ms. Perkins. I'm asking the officer. What was the basis of the obstruction charge? I guess that's a more direct question.
The obstruction charge that I charged him that he refused to give me his name after I asked him for his name numerous times. Which he told me that he told me to find out that
Okay,
obstruction my investigation.
okay. Ms. Jefferson, do you have any questions based upon the question I just asked?
I do, just a point of clarification. He was already detained or in custody in relation to the shoplifting charge when you encountered him to get more specifics about his name. Am I correct in that or no?
So when I encountered him, so I put him. I thought about the more security and verified that was him. So I put him in the handcuff and then I start asking for his name, which he refused to do so.
That's all I have. Thank you.
Okay, Mr. Little, do you have any other questions based upon what the question I asked?
No, Your Honor.
Okay, may Officer Lamb be excused?
Yes, Your Honor, the state will submit on the evidence.
Okay, thank you, Officer Lamb. Sir, you are gentlemen among men and your patience and being here. So you can be excused or you can stay if you want. Okay.
Yeah, I have returned back to work.
Okay.
Thank you, Your Honor.
Thank you. Have a good day, sir, and stay safe. So
Yes,
the
sir.
state has submitted on the evidence. Mr. Lane, I'm sorry, I put you out in somewhere by mistake in the digital universe. So I do apologize for that, but I'm going to come back to you in a second. Mr. Little, do you have any argument?
Your Honor, defense will submit on the evidence.
Okay. So I have a question. Mr. Perkins has a right to remain silent. And if he does not offer anything, does that form the basis of the obstruction charge? I have no questions about the shoplifting charge. But it appears to me that the obstruction charge is that he didn't offer to help the police, which he doesn't have a duty to do. So am I off base on that, Ms. Jefferson?
Your Honor, I would argue that the obstruction charge is appropriate as he was already detained and in custody in relation to the criminal act of theft by shoplifting. Had this been the reverse, where he was not detained or in custody as it relates to the theft by shoplifting, and the officer just walks up and says, what's your name? Then that's a first tier, and then no, we wouldn't have any issue. But because he was already because there had already been a criminal allegation or a criminal act, and he was being detained and in custody for that, and the officer was clearly in the lawful discharge of his duties, Mr. Perkins' failure to provide information to the officer in relation to the crime that he was being arrested for it is obstruction.
I'm gonna challenge you on that, Ms. Jefferson. And like I said before, if I'm asking questions, it's because I don't have the answer. Was he required to offer anything? I recall, again, didn't be an old man, but a person that was in Mr. Perkins' position in Fulton County 20 years ago, he'd be booked in as John Doe, and he'd be sitting there for a couple of days while they run fingerprints and try to figure out his identity. But I'm unaware of a duty to say anything. when you're being arrested. Now, the things that you say may be held against you, which you'll be told. But if you say nothing, it's hard for me to figure out how that's a crime. But I'm gonna give you the opportunity to change my mind.
Your Honor, I think the key ingredient here is the custodial situation. I think that's the key ingredient. Like I said, had that encounter happened before, then I would have a weaker argument. But I think because he was already in custody, I think that particular circumstance matters in relation to acquiring information from the suspect or from Mr. Perkins and his refusal to cooperate with the officer and the officer's lawful discharge of his duties.
Okay, I'm gonna ask Mr. Little to respond, but you're gonna get the last word, Ms. Jefferson. Mr. Little, you
Well, I mean,
heard my
you-
question.
Your Honor, as to the being in custody, I mean, when a person's in custody and they're being interrogated, that's the exact situation in which a person should be Mirandized, to be told specifically that they have the right to remain silent and don't have to provide information to the police when they're being questioned. So, I mean, had Officer Lamb Mirandized my client when he was brought into custody, then he would have been informed that he had the right not to give information to the police. He didn't prevent them from being able to identify him. He submitted to the being fingerprinted. They were able to identify him. But I mean, if this really turns on whether or not he's in custody, then I think that strengthens the idea that he would have the right to remain silent, because those are the circumstances under which a person would normally be Mirandized.
Ms. Jefferson, you get the last word.
I think that's a really good argument. I was sort of waiting, I was anticipating that would be your argument, Mr. Little. However, part of the arrest process, the booking part, asking questions, that's not under Miranda. So again, it's the outward intentional deflection, it's the intentional interruption or the intentional obstruction, for lack of a better word, of the officer being able to carry out his lawful duties. He interfered with the process of the investigation, interfered with the process of the officer being able to do his job. That qualifies as obstruction, in my opinion.
No, I'm here to listen and to be educated. I'm gonna dismiss the obstructing an officer charge, but the theft by shoplifting, I find that there's sufficient evidence for that to go forward. It's the I guess the colloquial thing that I'll use as by way of example is, as a judge, I'm here to listen and to make a determination. Now, you can give me a 30-minute oration, or you can give me a 5-minute presentation, but you're not obstructing me in doing my job as a judge if you go 30 minutes versus 5 minutes. And so if a person lays down and officers have to lift that person up and take them to the car, I don't see that as obstruction. It is not something that I would recommend, but at the same time, if you arrest somebody, it's your job to, as Roscoe P. Coltrane would say, to cuff them and stuff them. And so the fact that you don't go along quietly, I don't see that as obstruction. And I could be wrong, Ms. Jefferson, but the theft by shoplifting is going to be bound over to state court of Clayton County to be tried. I'm dismissing the obstruction of an officer charge. Now, Mr. Perkins, you need to understand that Ms. Jefferson can go the next 30 minutes and write up an accusation and recharge this obstruction. The fact that I've made this determination in no way stops the state from moving forward if they believe that they want to proceed on that charge. So it may be a short-learned or short-lived victory, but for the moment, this charge is going to be, the obstruction charge is going to be dismissed, but theft by shoplifting is going to be bound over to the state court. Now, Jackie Fleming, can we get Jackie Fleming on the screen?
In effect, maybe? Yeah, that's the female. That's it. Lady 34.
And Mr. Lane, I do apologize. I was trying to get you over into the same room with the jail, but I'll call it user error on my part, that I think I placed you in like a breakout room or something. So I still am going to get you in that opportunity in that room to speak to your client, but I do apologize.
Oh, no problem, Judge. I appreciate it.
Okay. Officer Kilgore, how are you doing today?
Good, Your Honor. Yourself?
I hope we haven't wasted too much of your day. It's after 11 now. Wow. I'm gonna try to get this stuff done. Miss Jefferson, with the cases where we don't have the officers here, I'm going to start calling those cases in a minute. If the officer's not present, those cases are going to be dismissed. With Officer Farley, that was a case I think we're waiting on. Was it you, Mr. Lane, to speak to your client?
Yes, Your Honor. Yeah, that'd be the case with involving Mr. Willie Williams.
Okay. And at the jail, my understanding is that Mr. Williams was supposed to be somewhere else, but he is present.
Yes, Your Honor. And I was actually visiting with him, and I guess we were back there with all the people we had to meet with, and we got timed out, and it just automatically put us all back into court with everybody.
Okay. So Officer Farley, I'm sorry, I'm gonna have to give Mr. Lane the ability to speak with his client, but we're gonna call the case of State of Georgia versus Jackie Fleming. And this is position 6 on my calendar. And Ms. Fleming is charged in warrant number 2022 WA08006 with committing the offense of simple battery, family violence, and charged in warrant number 2022 WA08007 with committing the offense of criminal trespass, damage to property. Ms. Fleming is here represented by Mr. Little, and the state is being represented by Ms. Jefferson. Ms. Jefferson, you can swear in your witness and proceed with your examination.
Officer, if you could raise your right hand to be sworn in. Do you swear or affirm that the testimony that you're about to give in these proceedings is the truth and the whole truth and nothing but the truth, so help you God?
Yes, ma'am.
And if you could lower your hand and tell us your name and where you're employed.
So Officer Kilgore, I'm employed with the Clayton County Police Department.
And were you so employed with the Clayton County Police Department on the 11th of May, 2022?
Yes, ma'am.
And were you dispatched to 3801 Anvil Block Road in Eaglewood Georgia, Clayton County?
Yes, ma'am. It's Ellenwood. Yes.
Oh, okay. Ellenwood. Yes, I see that. And the basis for the warrants that were taken against Ms. Fleming, the battery and the criminal trespass warrants, could you provide us with those facts and particular information you obtained when you were dispatched?
Yes, ma'am. So I was dispatched to that location by the live-in manager of that residence. He said that one of the residents had been assaulting members of the staff. We get there and I made contact with the victim. He stated that he had tried to break up a dispute between the defendant and another employee there. And he said that the defendant had grabbed this other employee's purse, wouldn't give it back. He went down to break it up. And then the defendant attacked him, leaving visible injuries. He said that she punched him in the back and then scratched his head. He then showed me his injuries. It was a bruise on his back and a small laceration to the back of his head. He said after that she attacked him, they were able to separate, and then the defendant grabbed a vacuum cleaner and then swung it at him. It didn't hit him or anyone else, but it damaged the sheetrock. And then I saw the hole in the sheetrock.
And you said that she was a resident. What type of a residence was this?
It was a group home. That's what the information we provided. He said so. It was a group home.
Okay, so it wasn't a situation where they were connected by family. They were connected because this was a transitional type of residence.
It was a group home, and we charged her with family violence stuff because the victim was the manager that lived there permanently. So he informed us that he lived at that residence.
And she lived there
yes,
as well?
She lived there as well.
Okay.
Yes.
So you saw visible injuries on him?
Yes.
Did you see visible injuries on anybody else?
No, ma'am.
And you said that he said that she picked up a vacuum cleaner and swung it at him?
Yes.
Okay. And so was the vacuum, can you describe the vacuum? Did you see the vacuum cleaner broken?
The vacuum cleaner was not broken. I did see, if I remember correctly, some sheetrock dust on it, but the vacuum cleaner itself was not damaged. The criminal trespass charges for the damage to the wall.
Okay, but you saw the damage to the wall?
Yes. Yes, ma'am.
Okay. And who identified the value regarding the damage to the wall?
I believe it was the victim. It was the victim or another employee there.
And you said the vacuum cleaner was not damaged. Was the vacuum cleaner, can you describe the type of vacuum cleaner it was?
I cannot recall, ma'am. It was just a standard, normal vacuum cleaner. I don't know the make or the brand.
Well, let me ask you this. Was it a vacuum cleaner that stands up, or was it a vacuum cleaner that sits down?
Stand-up one, a normal stand-up one, and then you put your foot on it to lower or adjust the angle of it.
Okay. Did you happen to pick up the vacuum cleaner, or did anybody pick up the vacuum cleaner to give any indication as to how heavy it was?
Not that I recall.
And you were the one that actually arrested Miss Fleming, and did she make any statements?
The only statement I can remember her making or recall making was that nothing happened.
That's all the questions I have.
Mr. Little?
Thank you, Your Honor. Officer Kilgore, You had a body worn camera during this investigation?
Yes, sir.
Okay. And it's you personally interviewed the witnesses on scene for this?
Yes, I obtained statements from the victim and another witness.
Did
Written
they
statement.
do written statements as well?
Yes, sir.
Oh, okay. Did any of them give you any indication of Miss Fleming's mental health status?
I cannot recall. I mean, it was a group home, so I'm sure there might be some mental health problems there, but I can't speculate on that.
Okay. The alleged victim in this case, I guess Mr. Hudson, he told you he lives there?
Yes.
Is his living space separate than the living space of the other residents of the group home?
Yes, I believe it was a multi-story house, and his is on the first floor, and hers is almost downstairs. It was like a split-level home.
Were there other?
So they don't live in the same room, but they live in the same address. I mean, not the same room. They live in separate rooms.
Would this be a living situation where they would share common areas,
Yes.
like kitchens and bathrooms?
Yes.
Okay. Were there any other residents that lived on the first floor?
None that I spoke to.
Okay, so just as far as you know, Mr. Hudson was the only person that lived on the first floor.
Yes.
Okay. And he's an employee of the group home?
The manager of the group home was what he told us. Or told me.
Do you know who owns the home?
I asked him, and he said he didn't give me a name. He said it was someone else actually owned the home, but he is the manager of the home.
Okay, but you weren't able to ascertain who the owner of the home would be?
No, sir.
Okay. Those are the questions I have at this time.
Okay, any follow-up, Ms. Jefferson?
No follow-up, Your Honor. The state rests.
Okay, may this officer be excused?
Yes, Your Honor. I may have a brief argument, but yes.
Okay, Officer Kilgore, you can be excused or you can stay. It's at your leisure while I entertain arguments. So, Ms. Jefferson, are you gonna waive opening and just go to just final or?
Yes.
Okay, Mr. Little.
Your Honor, as to the criminal trespass, I would argue that we don't know who the alleged victim of that criminal trespass is. We don't know who owns this home to know who would be at a loss for the alleged damage. My other worry then is that we don't have also competent evidence of how much that damage would be worth. I know Officer Kilgore said somebody told him it would be about $200, but I mean, we don't know where that estimate came from, if it's just a wild guess. But more importantly, we don't actually know who owns that property to know who the alleged victim would be on this case. As to the battery family violence, my main argument on that is with the family violence component, Your Honor. The battery statute says that a case is a battery family violence if it defines household members as past or present spouses, persons who are parents of the same child, parents and children, step parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household. My worry is, Your Honor, this living in the same household doesn't necessarily contemplate you living with someone who is paid to live in that household. The manager of this group home is an employee of the group home. This is their job to be at that group home and to live with these residents. Officer Kilgore testified that his living area was separate than the living area of the other residents of the home. His room is on the first floor. The other residents are on the second floor, showing that they do have separate living spaces and they're not living together in the way that a family would live together for the purpose of the family violence statute. It's more like living in the same area as someone who's running the property. It'd be like living, if a hotel manager has a hotel room near yours, it doesn't mean that you're living together as a family. That I don't think this is the type of relationship that the family violence statute is contemplating. So I'm not necessarily arguing against the battery probable cause, just the family violence component on that one, Your Honor.
And that's a novel argument, Mr. Little. I would tend to agree with you on just I guess the public side of your argument, the common sense side of your argument. I'll say that, but the statute says something different. And which I try to do is read the statute and follow what the statute says, whether I agree with it or not. So, Ms. Jefferson.
I appreciate Mr. Little's argument, but reading the statute, it says there's an or other persons living or formerly living in the same household. And I think looking at the text of the statute would qualify this under, that particular section. That's the family violence battery. I think the evidence or the testimony was pretty clear that a battery had occurred. Visible injuries were there. The criminal trespass warrants, as it relates to the damage to the property, at this time, the standard is, is the probable cause standard. And I think there's sufficient evidence of the officer investigating to determine a value associated with the damage that was done by Ms. Fleming. But I do want to make another argument, and that relates to the questions around the swinging of the vacuum cleaner. This may be stretching it just a bit, but I do think that there may be sufficient evidence to bind this over as an aggravated assault. The statute 16.5-21 talks about an object, device, or instrument which, when used offensively against a person, is likely or actually does result in serious bodily injury. The officer testified that Ms. Fleming picked up a vacuum cleaner and swung it at him. She missed and she hit the wall instead. Had she not missed, he would have been swung with an object when used offensively against a person is likely or actually does result in serious bodily injury. It damaged the wall. So had that been a body there, he could have received serious bodily injury. So I would ask that the court consider binding this over as an aggravated assault.
So, Ms. Jefferson, that is also a novel argument. I heard you ask about the weight of the vacuum cleaner, and I didn't understand where you're going with that, but now I understand where you're going with that questioning. I'm not going to bound it over as an aggravated assault, but and I know that whatever I do here as a prosecutor, you can undo. Not charging it as a felony, that's going to have to come from the district attorney's office. And so that may be over a drink of coffee or whatever that you convince someone on that argument. I would ask you to consider sort of a different step of backing down from some of the things or arguments as it relates to aggravated assault, because you're right in the sense that an object, and that's something we got to figure out. Whatever object. Sometimes they say, "Oh, it's your fists," and that leads to aggravated assault charges. And I think we need to define our words more. So I'm not going to bound it over as a aggravated assault, but I am going to bind it over as a battery and criminal trespass, damage to property. Mr. Little, your argument as it relates to the ownership, that is that is a live issue. But the fact that I heard testimony about being a rooming house, that means somebody else has an ownership interest. And you don't have to have complete or whole ownership. You just have to have some ownership. And so I think that element has been met. So I'm going to bind this case over, both charges over, to the state court of Clayton County. And I'm getting tired, but we ain't even got to the criminal trespass discussion I wanted to have with you all. So we have before Mr. Lane, before I get to you, Miss Jefferson, this is the point in time where if these officers have not logged in, I'm going to call these cases and I'm going to dismiss them for want of prosecution. So we're going to begin with position number 1, Rashad Battle, and Officer Loudon. Do you have Officer Loudon available as a witness in this case?
I will sound for Officer Daniel Loudon. Officer Daniel Loudon.
Okay.
No response, Judge.
Okay, that's going to be dismissed for want of prosecution.
Your Honor, do you want me to prepare the order for that?
Yes, sir, please.
Will do, Your Honor.
Mr. Lane, this is your case. Jesse Bray, you had a pretrial. Was that a hearing? Oh, you're muted, Mr. Lane.
Yeah, on Jesse Bray, no, I was able to meet with him, and we're going to announce ready for hearing.
Okay. Miss Jefferson, I have an Officer C. Headspeed that I do not see on the call. Do you want to sound for your witness?
Officer Craig Headspeeth. Officer Craig Headspeeth.
Okay.
No response, Your Honor.
Okay, that's going to be dismissed for lack of prosecution. We have an interesting situation on position 4, Lucky Brock. That's also Officer Loudon, but it looks like Mr. Brock, or I believe it's a Mr. Brock, is representing himself, and Officer Loudon is not here. So do you want to sound for Officer Loudon once again?
Officer Daniel Loudon. Officer Daniel Loudon. No answer, Your Honor.
Okay. We have Officer, looks like Christopher Joseph, that is logged on now for position 5, Marquise Busby. Who's handling that, Mr. Little?
David Sell, Your Honor.
That's going to be you, Mr. Sell?
Yes, sir.
Okay, so we have the officer. I'm going to come back to that, but I'm going to finish sounding for these cases where it appears that the officer hasn't appeared. And we have, looks like Officer Cruzline. So Officer Joseph and Officer Cruzline, it appears, are going to be our last hearings for today. And I'm just going over my calendar. All right, with Mr. Williams over at the jail, were you able to get contact with Mr. Willie Ernest Williams Jr.?
William.
There was a case where I believe that he may have been in another courtroom and it may have to be continued because he's in another courtroom.
How you doing, sir?
Okay.
Actually, Your Honor, yeah, Mr. Williams, this is the same Mr. Williams I was meeting with, and our meeting got cut short.
Okay.
So that,
Okay. Mr. Williams, I am going
sir.
to, I'm going to do a hearing, but I'm going to place you in a breakout room soon so that you can speak to Mr. Lane, and
Sure.
Officer Farley is who I have, and Miss Jefferson. I'm gonna. Oh, Miss Farley is still, looks like she's still here. So I'm not gonna hold you up or harangue you with that case because our Farley's been waiting here patiently.
Yes, sir.
The Dominique Alexander, that's going to be continued to June 7th. Is that your understanding, Mr. Sir?
That is correct, Your Honor.
Okay. I have a Khadijah Delaveau with an Officer Bowling, and I don't see an Officer Bowling. That's your case, Mr. Little.
It is.
Miss Jefferson, do you want to sound for Officer Bowling?
Officer Evan Bowling. Is there an Officer Evan Bowling? Your Honor, this is these are charges of battery and assault. These are charges, against a person. We would ask that be continued to the next calendar, the next available calendar, because of the nature of the charges.
Your
So
Honor, I
that
would
we have
point
an
out,
opportunity to get the officer.
and Your Honor, this is the third time Ms. Delaveau has been on a preliminary hearing calendar. She was here on May the 10th. She was here on May the 24th. She was here on today, May the 31st. And every one of those times, Officer Bowling didn't arrive and the state asked to continue it to allow him to have a chance to find Officer Bowling. This is the third time, Your Honor. We would ask that this be dismissed.
Miss Jefferson, what's your response?
Your Honor, I'm not privy to the prior actions. I'm just looking at the nature of the charges. And we would ask that the court allow another opportunity because of the seriousness of these charges, that the case be continued one more time.
Ms. Jefferson, I think based on the knowledge that I've been told there's been 3 times, I'm gonna dismiss this for warrant of prosecution. Of course, you can bring charges back at any point within 2 years of the alleged crime. Mr. Little, I need you to present me with a dismissal order.
Hearing it now, Your Honor.
That I will sign. And and this is something that I would really want to know, Ms. Jefferson, and we can talk about it offline about just how the charging procedures go, because I've heard certain things about how charging happens, and it comes and your hands may be tied in the solicitor's office or the DA's office before stuff moves out of magistrate court. So I don't understand that process, but I'd love to understand it because, as a prosecutor, you can charge a case at any time when you believe you have the evidence that's there. And I'm not saying you personally, but just you standing in your position as an assistant solicitor. And I was told that for some reason, based upon the computer system or whatever, that's not possible. But I really would love to hear from your side how that whole process works. So maybe we can have that conversation in conjunction with
Your Honor?
trespass. Yes, sir.
So what's the name of the individual that case got dismissed?
It is Mr. It's well, maybe Miss Khadija Delaveau, Deleveaux.
Okay, sir.
Okay. All right. Thank you. Mr. Corey Morgan. It looks like the witness is Shanta. It says LAT Franklin. Go ahead.
I got information from the investigator that the officer was on the Zoom.
Okay.
I'm not sure where now, but I got information a few moments ago that the officer was present.
Okay.
Let me just check with them again to make sure.
Yeah. Yes, ma'am. And I'll give you that opportunity. Sanchez Simmons. This is a case that I think is Mr. Lane's case, but there's a need for an appointment order.
Yes, Your Honor.
Is that correct? We have Officer Cruz Leon on. Are you, Mr. Lane, ready to go forward on that case?
Yes, Your Honor.
Okay, and I'll do the appointment order.
I'm knocking on the door.
So we're gonna, before we bring up Simmons, we're gonna bring up the case for Officer Farley. Let's see. So based upon what I have now, looks like we got 3 more cases to go. Marquise Bushby. I'm sorry, I'm gonna call Officer Farley's case first. And I just gotta get to the name. Willie Ernest Williams. Are you Mr. Williams?
Yes, sir.
Okay,
There we go.
and this is gonna be your case, Mr. Lane.
Yes, Your Honor. And this was the one that I was needing to speak with Mr. Williams real briefly. Real quick.
Okay, all right, stand by. I'm sorry.
Shouldn't be long, Judge.
It's we got Officer Christopher Joseph, Marquise Busby. That's Mr. Suh's case. I'm gonna try to get these out of the way, Mr. Lane, just so you can speak to your client, and that'll be the last thing
Okay.
that we'll do. So at the jail, Mr. Williams, you can go off camera. We're gonna bring up Mr. Marquise Busby, BUI. And we have Officer Joseph here. I think I've been told I need to drink protein drinks. The Snapple and don't tell Miss Mary, I know she's listening, but the occasional Coke, or the Coke drink, not the not the pharmaceutical Coke.
I'm
And-
telling you, we're gonna be looking for a new assistant soon.
See how Miss Mary do me? But I gotta, I start my day at 7. And I'm getting prepared and all this stuff to be ready to look beautiful for you guys on camera. And witty and all the other stuff that I try to do. Okay. You are Mr. Busby, correct? Mr. Busby, this is going to be your preliminary hearing today. And for the record, it's the state of Georgia versus Marquise Busby. Mr. Busby is charged in warrant number 2022 WA 08193 with committing the offense of battery. He's represented by Mr. Suh. And the state is represented by Ms. Jefferson. Ms. Jefferson, would you please swear the witness in and present your case?
Officer, can you raise your right hand? Do you swear or affirm that the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, thank you. Can you lower your hand? This is a little unusual because your cap is shielding your face, so
Oh,
I don't see anything.
oh, I'm sorry.
Okay, yeah, now I can see your face because there was just a void there. Okay, officer, where are you employed?
Well, Clayton County Police Department?
And were you so employed on May 16, 2022?
Yes,
And did you respond to 2507 Rex Road in Ellenwood, Georgia, in Clayton County to a domestic dispute or domestic
Yes.
disturbance?
yes.
And can you tell us the basis for the family violence battery charge that you filed against Mr. Busby?
Yeah, so when I arrived on scene, I saw the victim, Veronica, with a huge knot on her forehead. Pictures are attached with the report. And she said she sustained that knot on her forehead from Mr. Busby grabbing her by the neck and throwing her down to the ground, and she hit her head on the door frame.
And what was the relationship between her and Mr. Busby?
Boyfriend and girlfriend, and she's 7 months pregnant with his child.
I'm sorry, you said that you took photos as well?
Yes, they're attached to the report.
I have nothing further.
Mr. Suh.
Thank you, Your Honor. Good morning. I guess good afternoon, Officer Joseph.
Hey, good afternoon.
All right. So it looks like in your report, you indicated that Mr. Busby stated that that injury occurred a different way. Could you please tell us more about that portion of your report?
Yeah, he claims she was sitting on a washing machine, and she attempted to get up, and she slipped and she fell.
Did you go ahead?
No, I was gonna say, but she denied that. She denied that that's how it occurred, and I don't know if you saw the picture, but it's not consistent with someone slipping and falling. It looks like an injury more so that was done by an individual.
And how did you determine that? How did you come to the conclusion that it was an injury that occurred by a human versus a doorknob?
Because she also had other injuries to her body. She had some bruising, some scratches, some bruising on her neck as well.
Okay.
Consistent with her stating that he grabbed her by the neck and threw her to the ground.
Now, the alleged victim, Miss Graves Smith, she indicated that they were in a altercation before things got physical. Is that correct?
Yes.
Okay. And did she mention any attacks that she gave, any mutual fighting that occurred?
In that current incident,
Yes, correct.
I believe she did say she did something, but it was to defend herself.
So she claimed that she was defending herself.
Yes.
What about the portion that talks about the pepper spray? Could you tell us more about the pepper spray in your report?
Yes. So he mentioned that she did use pepper spray, and we went into the home. We went into the room. We took him to the room that he, alleged she used pepper spray on him. And pepper spray lingers around. And myself and two other officers, along with Mr. Busby, was in that room, and there was no sign or indication that pepper spray was deployed. And Mr. Busby showed no signs or indication that he had been pepper sprayed. Nothing was wrong with his face, his eyes. He looked perfectly fine.
About how much time would you say passed between the time the call came into dispatch and the time that you were able to arrive at this location at Rex Road?
Probably anywhere between 10 to 15 minutes.
Did you check Mr. Busby for any injuries on his body, his person, his neck, anywhere on him, the defendant?
Not that incident. So we responded multiple times to this location. Mr.
Okay.
Busby did sustain a few minor scratches on him, but from an earlier incident.
Are we talking about the same night, the same evening, or a completely different day?
Well, it was before midnight.
Okay, so within, I guess more specific, was it like within a 12, 24-hour time period? That
Yes,
we're talking
yes,
about? Okay,
yes, it
okay,
was.
Okay. This is probably my final question. Did you find any pepper spray in the vicinity at all?
No.
All right. That is all the questions I have at this time.
Okay, Ms. Jefferson, do you have any follow-up?
Just one question. From your investigation and from your questioning both individuals, who did you determine was the primary aggressor?
Oh, is that you're talking to me?
Yes,
Ms. Jefferson?
sorry.
Oh,
Yes.
oh, repeat the question, please.
From your investigation and from your inquiry and questions asked, who did you determine was the primary aggressor?
At this particular incident, Mr.
Yes,
Busby.
the incident that occurred 16th of May.
Yeah, Mr. Busby.
Thank you. Nothing further. The state rests.
Any follow-up, Mr. Saw?
No, Your Honor, not this time.
Okay, may Officer Joseph be excused?
Yes, Your Honor, and the state will submit.
Okay, Mr. Suh, do you have any argument?
No, Your Honor, we have no witnesses, and we will submit on the evidence as well.
Okay, based upon the testimony that I've heard, I'm gonna bind this case over to state court of Clayton County. And Officer Joseph, you can be excused, and Mr. Busby can go back to his housing area. Now, from my calendar, I have Williams, Morgan, and Simmons as the three cases that are remaining. Is that correct?
Correct for Morgan?
I think there's a
Which is-
position 46.
Probably in 2 weeks,
Okay.
unless you get your stuff out out. That's the best thing to do.
He's a fucking liar, man.
That's Tracy Mathis.
Yes, Your Honor.
Your Honor, I submitted a order for a judicial bind over due to her mental health status.
Oh, that's right. That's right.
Yeah, yeah.
Sorry, forgot about that.
There's a note. There was a note that I have that there's Mr. Little's going to try to find bed space for this person, but
We can do that from state court, Your Honor.
yes, sir.
Get my lunch out there.
Yeah, yes.
So Simmons, Morgan, and Williams, and Mr. Lane needs to speak to Simmons
Williams.
and Williams, or is it just Williams?
Just Williams, Your Honor.
Okay. So with position 48, Ms. Ferguson, Corey Morgan, I don't see.
You called me Ferguson again. That slipped out.
I did. Did I do that?
Yes, you did.
Oh my oh my God. I'm gonna have to sit on a psychologist's couch somewhere. It's why I'm calling this lady I met for the first time. I keep calling her Ferguson.
Well, Your Honor, as it relates to Corey Morgan, unfortunately, I was mistaken. Investigators and victim advocates. Officer Franklin is not on.
But you're breaking up. I didn't hear anything after Officer Franklin is not something.
Yeah, my internet's getting tired. Officer Franklin, unfortunately, I was mistaken, and I do not believe Miss Franklin, Officer Franklin.
Miss Jefferson, not Ferguson. You're breaking up. So
Still?
I need you to, yes, I need you to say it in short form, not long form. So what are we doing with Corey Morgan?
Officer Franklin is not on the call. However, this is a very serious offense of battery, and we would ask that be continued to the next available calendar.
And Your Honor, if I may chime in now, Your Honor, this is our third time being here as well. We've had a preliminary hearing on the 10th of this month, the 24th of this month, and we're here today. The previous two preliminary hearings, no excuse was given as to why there were no officers or there were no witnesses, except that they were not available. Nothing about training, anything that would allow the court to have an excuse to continue the case. The case has already been continued twice because there has been nobody present to testify against Mr. Morgan. And we are asking again, and the third time, there's nobody here. I mean, if this was a serious enough case as has been stated, then where are the officers? Shouldn't they show up for such a serious case? Your Honor, we're asking that the charges be dismissed for lack of probable cause. He is in for one count of battery. And as I said before, Your Honor, no excuse has been given as to why the officers are not present. And this is the third time, Your Honor.
Ms. Jefferson, I think I'm gonna have to agree with the defense. I don't take any pleasure in this because I don't know this person. And I don't know what this person is gonna do. I know the charges, I know the allegations, and God forbid this person is released and they do something else. And I know I'm going to be the person that's going to be blamed for it. But if this person was arrested, officers should at least make it to court. And I don't, like I said, I don't take any joy in that, but my job is to look out for the interests of both sides, not just one side. So I'm going to dismiss this case for want of prosecution. Mr. Sub, would you present a proposed order
Yes, Your Honor. Absolutely.
and share it with Ms. Jefferson?
Absolutely.
And there's,
Your Honor, what's the gentleman?
I'm sorry,
So what's the gentleman name?
Mr. Corey Morgan.
Okay, sir.
Okay. So now that leaves us with two cases that are Mr. Lane's cases. And I'm going to place Mr. Lane. You said there's only one client, though, that you need to speak to. Is that correct?
Yes, Your Honor, that's Mr. Williams.
So can we move forward on Mr. Simmons or Mrs. Sanchez Simmons?
Yes, Your Honor.
Okay, we have Officer Cruzline here. So Officer Farley, it looks like you're going to be the last person today. If you got to blame somebody, blame Mr. Lane. I'm certain you can find his address and go just sit outside his house. So at the jail, we need Sanchez Simmons. Is that the person standing before me? You're muted, sir, so I can't hear you. You're muted. I cannot. So, sir. Sir, I just wait until we unmute it and then.
Yes.
Yeah, okay.
No, I'm Willie Wood.
Willie.
Yes,
Okay, sir. You're gonna have an opportunity to speak with your lawyer, Mr. Lane, before we go
Yes, sir.
forward with your hearing.
Yes, sir.
But I'm gonna do Mr. Sanchez Simmons now,
Yes,
or
sir.
Ms. Sanchez Simmons now, and then just stand to the side
Yes, sir.
and just tell him I need Sanchez Simmons.
You want Simmons?
Yes, sir.
Okay, sir. Mr. Simmons? Simmons?
Mr. Lane, the older I get in life, I just like to spend time with my chickens. That's how my chickens, they're judgmental as anybody else. But they're lovely animals. So we have Officer Cruzline. For the record, it's going to be stated position 49, State of Georgia versus Sanchez Simmons. Ms. Simmons is charged warrant number 2022 CW 51803 with committing the offense of criminal trespass. Mr. Simmons is charged in warrant number 2022 CW 51804 with committing the offense of battery. And Mr. Simmons is charged in 2022 CW 51805, but I don't have a charge. What's the charge in that?
That's child cruelty, 3rd degree, Your Honor.
Okay, child cruelty, 3rd degree. Mr. Simmons is present. He's represented by Mr. Lane. State's been represented by Ms. Jefferson. Ms. Jefferson, you can swear in your witness and present your case.
Officer, your hand up. Do you swear or affirm the testimony that you're about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. And if you could state your name and tell us where you are employed.
I'm Officer Cruz Leon with the Forest Park Police Department.
And were you so employed on the 10th of March, 2022?
Yes, ma'am.
And did you respond to 1409 Rock Cut Road, Sheridan House Apartments, to a domestic disturbance?
Yes, ma'am.
And what city is that located in?
The city of Forest Park, ma'am.
And is that in Clayton County?
Yes, ma'am.
And can you tell us the basis or the facts that support the warrants or the charges of criminal trespass, damage to property, battery, and child cruelty in the third degree against Mr. Simmons?
Yes, ma'am. So on Thursday, the 10th of March, I responded to 1409 Rock Cut Road, which is the Sheraton House, apartment Charlie 1. I met with Alexis Bryant, who stated that her friend Sanchez Simmons was no longer on scene and choked her and broke her TV.
Okay. And can you tell us about how she's saying that she was choked? Can you give us a little more information on that?
Oh, yes, ma'am. So it began with them arguing, and then he broke her, I guess, threw her TV down to the floor and stepped on her, breaking it. And then I guess they began arguing, and then he got her on the chokehold, the one-hand chokehold, because I guess he had her phone. And then when she got loose, she ran to the kids' room, and that's when he followed her.
Hold on, officer. Is it Cruz Leon?
Yes, sir.
Okay, Cruz Leon. Mr. Simmons, I saw you raise your hand. Sir, and I forgot to admonish you or just warn you that whatever you say during this proceeding is not privileged or private. It's best to speak to your lawyer first before you try to make any kind of statement. At this stage in preliminary hearing, the standard is really low. It's a probable cause standard, which is a 51%, if that's what you're thinking about. So could it have happened? Not that it happened directly the way that the person is testifying or any of that kind of stuff. Purpose for this hearing is for me to listen to the testimony. And then you can speak to your lawyer and let your lawyer advise you as you move forward, because it really is a small standard. So don't get yourself in trouble by saying stuff now just because you're trying to make a point. But if you haven't spoken that over with your lawyer, you may say the wrong thing unknowingly. But you have the right to speak. And so if I do not pressure people into speaking or whatever, but just understand that the officer is here to say what the officer observed and saw. And the prosecutor is asking questions along that realm. This is by far not a trial. So it's generally best not to say stuff unless and until you and your lawyer have spoken about it. And I understand that you were unrepresented and Lister and Hope has agreed to come on and represent you. So I would just ask you and possibly beg of you to don't put yourself in any deeper trouble. Do you understand that, sir? Oh, okay. And I'm sorry. Go ahead, Officer Cruzline. And I'm sorry, Ms. Jefferson, I interrupted your direct examination.
So I think the question, officer, was about, she said that she was choked, and I was asking you if you could provide more information as it relates to her saying she was choked. Did you see visible marks on her neck? Did she describe the manner of the choking?
No, ma'am, I didn't see no physical marks, but she decided he grabbed her like that. I guess her head was in here because he had her phone. I guess he was trying to take her phone, and she was trying to grab her phone, and he wouldn't give it to her. So I guess when she came for it, I guess he put her in a chokehold. So it was not with the hands, but more with the like that, like grabbed her in chokehold like that. She was able to get off, and I believe he ran or she ran to his room, to the kids' room. The guy ran to, yeah, she was able to get off, and Mr. Sanchez ran to the kids' room, and Miss Bryant followed, and I guess that's when they began to wrestle in front of the kids.
And the
So I guess
rest,
she was-
I'm sorry, the wrestling was over the phone, over getting her phone back?
yes, ma'am.
Okay, so how did she describe how he actually took the phone? You may have said that. If I'm repeating myself, I'm sorry. Did she describe how he actually obtained the phone?
No, ma'am.
All that you were aware of is that he had the phone and she wanted to get the phone back. Is that correct?
Correct, ma'am.
Okay. Now you said something about a television that was damaged.
Yes, ma'am. So she stated that Mr. Sanchez threw her television to the floor and stamped on it.
And
Because I guess he was mad.
do we have any information regarding the type of television or the value of that television?
Yes, ma'am. Pictures were attached. And she didn't know how much it cost because it was a gift. So she said basically like $300.
Okay. And who were the witnesses to not necessarily just the stomping on the TV, but the chokehold?
Nobody that I'm aware of.
Were there children involved or children present?
At the time of the chokehold, no. I believe the time when they went into the kids' room to wrestle, yes.
I'm sorry, you said that when there were children involved when they went into the room to wrestle?
Yes, ma'am.
Okay.
Not the time of the chokehold, nor the TV was damaged.
So what happened in the presence of the children then?
She just stated that they wrestled for the phone.
Okay. And their relationship, they were not living together, sharing the same household. Is that correct?
Correct. She stated that they were just friends, and he had asked her if she could spend a week with them, that he will pay them, but he was only there for one night. That's why I didn't put the family violence, because he only lived there. He only stayed for one night.
Eventually, did she retrieve her phone?
Yes, she did have her phone.
I have nothing further.
Okay, before we get started with you, Mr. Lane, Mr. Simmons, I did see you raise your hand again. I have to tell you, everybody that has been accused of a crime where the charges were eventually dismissed or they were acquitted at trial have gone through this process. And I've observed your emotions and the stuff you're doing. And sir, if you want to speak, I will allow you to speak, but you really should not speak unless you've sat down with Mr. Lane and told Mr. Lane everything that is on your side and what you're trying to bring forward. Because if you say something today, this is being recorded. And Ms. Jefferson and the people in her department, they will nail you to the wall with the words that you say. And you got to understand if you want to do it, you can do it. But and I'll let you do it. I mean, even Mr. Lane can't stop you from talking if you want to talk. My job as a judge is to let you talk, but this is being recorded. You can't take those words back. You can't say, well, what I had meant was. You can't do that. So I'm just trying to tell you, young man, don't get yourself in deeper water, deeper trouble, or whatever. Speak to Mr. Lane. Let him represent you. You may disagree with whatever you have to say, but Mr. Simmons, okay. Mr. Lane, I'm gonna let you ask the questions that you have. And Mr. Simmons is muted. But after you're done asking your questions, I'm gonna open up the microphone and he can say whatever he wants to say.
Okay, Judge, and I appreciate it. And just for the record, I did advise him that for him not to talk and to remain silent. And this is not a trial today. It's simply a preliminary hearing. We're not putting on any evidence. And but I understand that at the end of the day, it's his right if he wants to speak, but I've warned him and I've advised him strongly to remain silent during these proceedings. This isn't the time, and I know you've reminded him more than once and cautioned him, but at the end of the day,
if he wants to hang himself, he can hang himself. It, as they say, it makes me know, never mind. I really believe in the law, and I really believe in my job, and really believe in trying to do what I'm supposed to do. But at the end of the day, adults are adults and they make their own decisions. But go ahead with your cross-examination of Officer Cruiseline. And I'm sorry, Officer Cruiseline, I know you've been waiting. But
okay.
Thank you, Judge. Good afternoon, Officer.
Good afternoon.
Did you find it unusual that the alleged victim here didn't have any injuries?
I mean, all she said was he got in a chokehold like that. I don't ever seen somebody have any injuries from that. I don't think he pressed on it hard. I think he was just, because I guess she came at him, so maybe he did that, but I'm not sure.
So, but maybe he wasn't choking her.
Maybe he was, I don't know. That's all she said, that he put her in a chokehold. I'm just solely going by what she said.
But there weren't any injuries, correct?
No, sir. I did state it on here. I did ask if she had any injuries. She said she didn't have any.
Okay. And did you interview Mr. Simmons to find out his version of what happened?
No, he was already gone by the time I got there. I had asked her to call him, but he wasn't answering.
Okay. And it looks like you did take pictures of the broken TV.
Yes, sir.
Would you be willing to turn those pictures over to the defense?
Sure.
Okay. And did you ever determine who the owner of the television was?
She said it was. She said that somebody gave it to her as a gift, that it was hers.
Okay. And the children were not present when the television was broken or during the alleged choking. Is that correct?
No, sir. They were not present.
Okay. All right. I don't have any further questions, Your Honor.
Okay, Ms. Jefferson.
Officer, how old were the children?
Oh, let's see. I know they were below 7 years old. There was two of them, a boy and a girl.
And just so that I absolutely understand, they were present during the
wrestling. Yes, ma'am.
During the wrestling. Now, did she say that during that wrestling, did she make any allegations that he struck her, or?
No, ma'am.
They were just wrestling over a phone?
Yes, ma'am. She was trying to get his phone and he wasn't trying to give it to her.
Okay. That's all the questions I have. And I do have, well, I'm sure that there's going to be argument regarding this from the defense. But I do have some issues as it relates to the warrants.
Okay. Officer, let me ask you, because I may have been distracted. What's the basis of the criminal trespass?
So the criminal trespass for the TV, criminal trespass damage?
Yes, sir. That's where you allege that he jumped on the TV?
Yes, sir.
Or stomped on the TV? Okay. And battery, there's an allegation that she, the victim said that he strangled her, but you did not observe any like marks. Or
I didn't.
whatever.
I've looked, but I didn't see no marks.
Okay. And for the child cruelty, that's because there was young children that was in the room seeing them.
Them wrestling with the phone. Yes, Your Honor.
Over the phone. Yes, sir. Okay. Ms. Jefferson, Mr. Lane, do you have any questions based upon the questions that I asked?
I do, Your Honor. How large was the residence when this occurred?
So I believe it's a 2-room apartment.
And the children were in another room when the choke occurred, when the stomping of the television occurred. Is that accurate?
Yes, ma'am. Because I believe it was 8 a.m.
Okay.
So I believe she got up to get the kids ready, went back to the other room, and then that's when it happened.
Okay. So, being that the size, it was an apartment?
Yes, ma'am.
Okay. Being that the size of the apartment was small enough, the children were in earshot of the commotion occurring between the two of them regarding the TV stomping and the choking.
Possibly, but they didn't. To my knowledge, they didn't witness it.
Okay.
That's all I have.
Okay, Mr. Lane, you should be made aware that Mr. Simmons was pulled off of the camera feed because he just was not comporting himself in the manner that he should, and he was essentially making allegations that people are making up stuff. So he has, through his behavior, decided to exit himself from this proceeding. And I was going to give him the opportunity to speak, but that's going to be lost. So I'll hear argument.
Thank you, Judge. As for the simple battery, of course, we're just going to argue that there was no probable cause met on there. There weren't any injuries, there weren't any markings made, and the officers testified to this. And as to the cruelty to children, again, the TV being broken and the alleged choking, none of that was done within the presence of the children. And as the officer testified, even stretching it to quote unquote earshot of this going on, he couldn't and didn't say that they were even within earshot. He just simply said it was possible. So just on the cruelty to children and the simple battery, we'd ask both those charges be dismissed. And the criminal trespass damage to the television would argue for the dismissal on that, just for lack of a solid value to the TV, or how much damage are we talking about of this television?
I was about to call you Miss Ferguson again, Miss Jefferson. At least I'm learning. Your Honor,
the officer did testify as it relates to the value of the television that was broken. She then said, or she told the officer that the value of the television was at around $300 as a gift. The children it was a two room or 2-room area apartment. And it was an apartment, not a house. So the walls presumably were thinner. With the commotion that was occurring around the stomping of the television and the chokehold, I'm sure that they were not silent. So I believe, even though the officer said probably as it relates to hearing and earshot, and the statute, does allow for that as far as seeing, hearing, for the 3rd-degree child cruelty. The simple battery is, she said that he choked her with his arm area, and that was an offensive touching. And the simple battery does not require a visible injury. There is the issue regarding the phone, though. He took the phone. They were fighting over the retrieval of the phone. That to me could be a theft, but I'll leave that with the court as it relates to that. And that's my argument.
Okay, well, I'm going to bond over the charges as they are presented. The testimony about the stumping on the TV is enough for the criminal trespass. The battery is written on my document as like battery school personnel. Testimony of the officer is like simple battery, where there's offensive touching, but officer did not describe seeing any marks. But that's the testimony that he was, or the statement that he was presented with. And I'm going to leave it over to the child cruelty in 3rd degree. And the thing, Mr. Lane, with your client is if people can't comport themselves in a courtroom setting, I just can imagine what they do behind closed doors. And the allegations that are made are serious allegations. And if he can't, as they would say, hold his powder and remain quiet until he gets an opportunity to speak, I can't imagine what he would do behind closed doors. So I've been in your shoes, sir, and I do not, I have compassion for you and what you may be going forward in dealing with this case. It's, this be last bit of personal privilege. What I will always tell people, if you spent this amount of time educating yourself before you were in jail, maybe you wouldn't be in jail. But you're in jail, and I went to college and law school, and you're trying to tell me what the law is. And from people that have told you certain things or whatever. So I'm going to stop because we got to get you into the room so that we can stop wasting Officer Farley's time. Mr. Cruz Leon, sir, thank you. You're free to go.
Thank you, Your Honor.
Today. I see Ms. Ferguson and Officer Bowling.
Just gonna make that a laugh. It's just funny, Ferguson. I mean, maybe I should just change my name. You did, and I'm thinking I'll just change my name for purposes of this Zoom. I'll change the bottom where it says Deborah Jefferson to Deborah Ferguson.
Well, ma'am, You have my permission to tell the whole world how much of a dumb behind I am that I can't remember your name. And I don't even know I'm saying it. And that's the crazy thing. Mr. Little, I thought
Yes,
we
Your
we're
Honor.
done with you, sir.
Oh, I mean, I was going to hang out to the end of the calendar, Your Honor.
You see, I'm gonna start charging tickets. There's Miss Jefferson, not Ferguson. Since Mr. Little don't want to join me in my little project of, I say, Zoom Chronicles, because you can't imagine the stuff that we see and the things that we deal with. Over at the jail, I'm gonna send Mr. Lane. Where are you, Mr. Lane? All right, I'm going to attempt to place Mr. Lane in breakout room 2. And I'm going to attempt to place jail in breakout room 2. Mr. Lane, you're gonna miss the story about the criminal trespass, because I'm gonna spend that time speaking to Mr. Little, Mr. Suh, and Miss Jefferson, and maybe Miss Bellow, if she can stomach having a conversation with me. Okay.
Your Honor, it says you've been assigned to breakout room 4.
Let's see. Yes, you are in breakout room 4. I'm going to move you to breakout room 2, just to try to avoid the problem we had before. So it's showing now that you and Mr. Lane and Mr. Sud, Mr. Little are all in breakout room 2. Okay, let me